welcome to Rightly Decided, the mostly originalist takes of the litigators of the Texas Public Policy Foundation. I'm Laura Beth Latimer, and I'm here with attorneys Nathan Seltzer and Clayton Calvin, as well as our Director of Litigation, Chance Weldon. Today we're bringing you a Supreme Court case from a couple weeks ago. Priscilla Villareal v. Alaniz, I think is how that last name is pronounced.
That's what we're going with.
Mm-hmm. That's what we're going with. And we're going to talk about the 12-eyed monster that lives under the bed of every plaintiff's attorney in the country, qualified immunity. This is a dissental. We've talked about that term before when Chance wasn't here. Chance, tell us how you feel about the term dissental.
I mean, it's a weird word, but I mean, it definitely specifies that it's not a dissent. It's like a dissent.
I think it
is a dissent, though. It's just a dissent from a denial.
Yeah.
So a dissental is a dissent from denying review by the Supreme Court. That's what I call a dissental.
It sounds like a made-up word, but
it is made
up.
up. Yeah. But I think there's a lot of words in English that have been made up that have served their role.
Well, this is not why we're here today.
It's kind of a portmanteau. So
yes,
Nathan, will you explain to us kind of the background of this case and get us teed up to talk about qualified immunity?
Yeah, so the case is about a social media journalist, and whether or not you think that's a real thing, it's a real thing for the purposes of this case. And the social media journalist was not liked by the police department where she does a lot of her reporting. And part of the reason for that is that she's investigating the police and maybe saying things that they don't necessarily like.
And this is Villareal here, the La Gordiloca, as she's known. Yeah.
What does that? What does that mean? What does that translate to?
I'm not an expert in Spanish, but I believe it means the crazy fat woman. And these are her words, not ours.
That's what she chooses to go by.
Yeah, that's her branding, and that's fine.
And
that's
she is disliked by, at least importantly, this is all of her allegations, right? So the factual basis of this is what she is alleging, that she is disliked by law enforcement in the area.
And there's perhaps some evidentiary corroboration for the fact that maybe they don't like her very much, which I'll get to in just a minute. Mm-hmm. So eventually she's doing some reporting on an issue, and she's looking for information about the names of some victims of some crimes and a suicide. And she's asking some public officials for the names of these victims.
I kind of think these details are important here.
Yeah.
So she specifically reaches out to a friend of hers in the police department.
Right.
And via text message asks for the names of a Border Patrol officer who had committed suicide and the name of a victim in a car accident with the intention of publishing that information. And she received that information, and then it appears that she published it, but we don't know that from the text.
And maybe not such a good friend also because she's prosecuted for asking. So we can kind of infer that perhaps he maybe told on her or something. At any rate, she's prosecuted. There's a statute in Texas. If you're asking how could she be prosecuted for asking a question as a reporter, there's a statute in Texas that is still in the books that prohibits soliciting information from a public official to obtain a benefit. And also wrapped in there is that the official has to only know the information as a result of their official status.
Yeah. Information that has not yet been made public.
Right. It's specifically non-public information as defined by the Texas Public Information Act. So it's really specific, but the Texas Public Information Act is very broad. It includes things like information about ongoing investigations, things like that. It's extremely broad in its definition of non-public information.
Nice, gotcha.
So she's asked for this information. It's probably not public because it's the names of victims of a crime or an investigation. And so it's probably illegal under the statute. But the statute is, if you're listening at home, you're probably saying that's probably not a constitutional statute. At any rate,
it's not.
Yeah,
I think we can just say it's not.
It's a good intuition.
Yeah, a judge eventually agrees on that point. And as we'll see, that's not enough to get Miss Villareal a remedy under the law, under federal law. So my screen just turned off. So the statute, a warrant is sworn out for her arrest. And she finds out about the warrant and turns herself in to police officers. She says in her complaint, and I think it's established that the officers surrounded her after she turned herself in. So she's like in the jail or in the police station, and they surround her, start making fun of her, take pictures on their cell phones. Not a good look for the police officers after she turns herself in.
And it's important to point out that they have never applied this statute ever before.
Right. Webb County has never ever arrested someone for this, according to her. And the state of Texas has never successfully convicted someone of this statute, every time it's come up before in the state of Texas, the district courts have dismissed it as unconstitutional. So,
and that's what happens here. So they bring the prosecution, and she brings dismissal. She motions to get it dismissed, and the judge says, "Yeah, the statute's unconstitutional. You can't be prosecuted under it." Case closed, right? Except that she was arrested. She had to mount this defense. All these things,
and she was booked into jail.
She was in jail. Yeah.
An important little procedural quirk of criminal prosecution is when someone is arrested, if they are put on bond, it means they were booked into jail and spent some amount of time in jail. It might have just been in a holding cell in the police department, but she was put in jail for this offense and then made bond.
I love all the criminal law background that you bring to this podcast.
Totally.
So after she's out on bond, she gets the charges dismissed. And then she sues under 42 U.S.C. Section 1983.
Our friends at IJ bring the case.
Oh,
yes.
yeah.
They represent
This
her.
is an IJ case.
Yeah.
Anya Bidwell, I believe, argued it at the Supreme Court.
Mm-hmm. And it's a righteous case. So she says that she was deprived of her constitutional rights by being arrested under an unconstitutional statute. So as a matter of law, she was clearly deprived of her rights.
And all these facts are as she alleges them to be, but in this posture, which this case goes forward, that's actually all that it matters.
Right. So because as you're saying, so like the court has to just take her allegations as true at this point. So even taking all of her allegations as true, the district court says that qualified immunity applies in this situation to all the police officers involved. She sues everybody. And all the police officers involved are immune under qualified immunity because there wasn't a clearly established rule saying that they were violating her constitutional rights.
So we'll come back to the qualified immunity issue in a second. But the long and the short of it is this goes all the way up to the Supreme Court. And the first time it goes to the Supreme Court, it's GVR. What does GVR mean, Chance?
To grant, vacate, and reverse.
So the court said decision of, in this case, the en banc Fifth Circuit is reversed. You guys go reconsider this, basically. It's GVR'd back to the Fifth. The Fifth Circuit issues another opinion, and then it goes back up to the Supreme Court and is denied cert the second time around in this case that we're talking about today.
Mm-hmm. But by the way, one little quirk of this thing. So she's convicted under 39.06C in Texas Penal Code, and it says that she can't solicit or receive public information. 39.06A and B say that the public official who's being solicited can't give the information because he's breaking the law. Mm-hmm. But we don't hear anything about the public official.
There was no case about that. Yeah.
So just like, I wonder if this is a little selective.
And weirdly, and I mean, like they would, I don't know. I think that they would have had to be prosecuted by themselves if they were ever going to be prosecuted under this law.
There's a process for that.
Yeah,
There's a process for that.
Gotcha.
We've got the Texas Rangers that do those investigations, and then it kicks either to the AG's office or to a neighboring district attorney for that kind of prosecution.
Here, but that's interesting.
Did not happen here.
It's sort of like if you bust in on a drug deal and you just arrest the buyer and not the seller. That's pretty much what's happened here.
Right.
So anyway, so the Supreme Court goes back to the Supreme Court, and that's where the posture of this case was about whether or not qualified immunity applies.
So, okay, all of this hinges on our 12-eyed monster, qualified immunity. So, Chance, I'm going to ask you to put on your law professor hat. Give us a primer on qualified immunity and what it means. Actually, before you do that, sorry, let me step back. I'm just going to read a little bit of the text of 1983 for people who don't know what we're talking about. So 42 U.S.C. 1983 was enacted in 1871 in response to the Ku Klux Klan. It was literally called the Ku Klux Klan Act originally. Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state, territory, or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. So that's the basis for most of our cases against state individuals.
And know how many times it says the words every and any. Every person who acts under the color of any statute and subjects any citizen to the deprivation of any rights.
Yeah.
It's extremely
very
broad.
clear and broad.
Shall be.
Isn't
Shall
there
be.
Shall
an
be,
except
shall
in there
be,
somewhere
yes.
though, right?
There
Yes.
is. The next
Which
line
we
accepts
can- yeah.
judicial officers for acts taken in their capacity, but that's the only exception that's in the text of this particular statute. So, Chance, tell us about the exceptions that are not in the text of this statute.
Yeah, so as anyone who practices on the plaintiff side knows, that text has not been given its original public meaning. So the statute was originally adopted to basically put some skin in the game for public officials who were enforcing unconstitutional laws, largely in the South during Reconstruction, then after Reconstruction. And this was the idea being that if there wasn't some federal forum to adjudicate constitutional rights, both for freed slaves, former abolitionists and such in the South, they just wouldn't get a fair shake in the state court system. Additionally, there was a real threat that government officials would just continue to enforce unconstitutional laws. So 1983 is passed to basically create a disincentive that you could sue the individual officer who's enforcing the unconstitutional law against you and get some form of damages.
It's
Right?
basically like an enforcement mechanism of the 14th Amendment after the Civil War.
As a matter of fact, it's Section 5 of the 14th Amendment gives Congress authority to make reasonable laws to enforce the text of the 14th Amendment, and the law that they adopt is 1983. It is harsh medicine for what is an extreme situation after the 14th Amendment is ratified in the states. And as you said, the language there is crystal clear. There is no immunity there. It is just shall be liable for any violation unless, of course, you're a judge. They knew how to create immunities.
But they did not.
They didn't create it for anyone but judges. And for the first almost, 80 years or so, 80, 90 years or so, that's true. You can actually sue government officials for damages for violating your constitutional rights. At around the time of the Warren Court, when the Warren Court is making up all sorts of new criminal procedure rights, they also create a doctrine of qualified immunity. And the idea is again, it's a policy argument like a lot of the stuff to come out of the Warren Court. They're policy making, and they say, look, it's not fair, particularly for police officers, though it applies to all government officials, but particularly for police officers, it's not fair for them to be held personally liable for damages for something that wasn't unconstitutional until yesterday. Right? Mm-hmm. And so they create this doctrine of qualified immunity during the Warren Court era.
So but for 80 years or so, there was no qualified immunity.
There was no qualified
so from the time it was passed until the 1950s. Yeah.
Yes, and as a matter of fact, there was actually earlier attempts to create something like qualified immunity for federal officials going back all the way to the time of the American founding. Early on, and there was a tax assessor case during the Marshall Court, the first Marshall, in the 1820s. I believe the name of the case was Osborne. And when the government official's attorney argued for something like immunity because he was just enforcing a statute, the court said, counsel is far too intelligent and has far too much self-respect to argue that a government official would be wholly immune from enforcing an unconstitutional statute.
Because that's one of the main ways that America was different from
from Europe. And then again, shortly after the Civil War, one of the early cases as well, the first time someone argues for a high level of immunity, in this case was they had taken property. And the court actually referred to it the first time that the government had argued for it, a federal official had argued for some form of immunity. The court referred to it as authoritarian and totalitarianism and communism, the dual progeny of the same evil birth, is the famous quote. Oof. So early on, the court had no patience for this idea. But by the time you get to the Warren Court, at least under 1983, they create this limited immunity.
And nothing happened, nothing changed as a matter of law.
Yeah,
this was just the court drifted.
The text has not changed. The court is creating this sort of pragmatic stopgap for all of the lawmaking that it's doing.
I also want to do just a quick 10,000 foot view for people who didn't go to law school. Immunity itself, like the concept of immunity, doesn't mean you win the lawsuit. It means you can't be sued at all. So when we're talking in this context about immunity in any capacity, the question isn't do you win at the end? The question is, can you even bring the suit and ask the question in the first place? So
even assuming all the facts that you've alleged are true,
right,
which you have to do under motion to dismiss, you can't even get in the door.
Yeah, it's important to say how qualified immunity works. It dismisses the case before there's discovery, before there's collection of evidence. It doesn't go to a jury, right? You don't get to have a trial if qualified immunity applies. Okay, so the court creates this doctrine of qualified immunity that says that there has to be, you basically can't ambush cops with new constitutional rights. Basically, there has to be, a reasonable officer would know that the thing that they were doing was unconstitutional. There has to be established law.
And the reason they're ambushed is that you actually sue the officers as individuals. So they're like personally liable for if they're violating your rights, which makes a lot of sense when you're enforcing like the KKK Act as what we think of those kind of violations. But it's not clear when you're a right that was just created like last year.
Yeah, that's the policy reason for why they created it.
Because the Warren Court was creating kind of new rights, and so they didn't want to.
We say creating, like.
Well, I mean, yeah, they were discovering, or however you want to put it.
Yeah, the Warren Court was kind of doing their own thing.
So they were like, well, since officers are not lawyers, so how are they going to know what rights that we are now aware of? So they kind of did that to mitigate their own.
And it was a policy judgment. And so then in the 1980s, they create this new two-step standard, right? And the two-step standard says in order, not only does there have to be a constitutional violation, but it has to be a clearly established violation. And the clearly established test, no one really knows what it means, but there's some debate about like how far it goes and how exact it has to be. You basically have to have a pre-existing case that's already been decided that looks almost identical to
decided by who, Chance?
Right. Well, there's a dispute about this, like at least by an appellate court in your circuit. Right. But some would argue more recently the Supreme Court itself.
But just the district judges, the other district judges in Texas that have passed on this issue is not sufficient. The other district judges that have said, okay, this is an unconstitutional statute, you can't prosecute these people under this statute, that's not sufficient. It has to be an appellate court in your district, in your circuit, in your wherever you are.
Right. So, for example, there have been cases where it says, the 6th, 7th, and 8th Circuit have already ruled this is unconstitutional, but we're in the 5th, so the officers there, it's not clearly established. They weren't on notice.
Yeah.
And so, and again, this doesn't apply just to police officers. It applies to all government officials.
And this also doesn't apply to, and I mean, this is going to the heart of the issue in the case that we're talking about today, to things that are so obviously unconstitutional that even a first grader would look at that and say, oh, that violates the Constitution. That is, in most cases, insufficient to hit that clearly established standard. You actually need a court to pass on it before we get there.
So that's been interesting. So that's been actually something else that's been shaking out in the clearly established test is, are there certain circumstances where even if there's not a case directly on point, it's just so obvious. And the Fifth Circuit, for example, recently there was a case a few years back where they had basically kept someone in a cell in their own feces for like days and weeks at a time. And the Fifth Circuit was like, you knew better than that, right? Like even if there wasn't a case.
It was obviously unconstitutional.
It was so obviously unconstitutional.
In that case, obviously a violation of the Eighth Amendment, not the First Amendment.
By contrast, there was a case out of the Ninth Circuit where a bunch of police officers literally stole money from someone's house and were granted qualified immunity because there was not a case directly on point saying you can't steal. And by steal, I don't mean seized and then like put it in an evidence locker. I mean took it. And so
under other circuits, it could still be the cops could do the exact same thing, and then the circuit might say, well, we don't have a case in this circuit about that, and so they could do it.
Okay, so then qualified immunity evolves. There is another gloss that's added in the early 2000s. This is a case that's written by the opinions written by Justice Scalia, and he says under the doctrine of constitutional avoidance, you can't even do step one. Was it a constitutional violation, unless you've done step two that says, it was.
Is it clearly established?
Right? Because his argument is you don't reach constitutional questions unless you have to. And so if it's unclear, so it's not clearly established, then there's no role for the court to even unpack whether or not it was unconstitutional in the first place. So you end up with this trap where the court never makes clearly established law on what is and isn't unconstitutional. And so the law never even progresses in that way. And that's sort of the place where we're at now with qualified immunity and how it works.
And there's an interesting wrinkle in that, too, dealing with Heck-Free-Humphreys, which we talked about a few weeks ago. Yeah. So theoretically, the only way that you can clearly establish something is unconstitutional is to bring a pre-enforcement case and bring it for a declaratory judgment, right? I want the court to declare for me that this is unconstitutional so that I can do this thing without being prosecuted.
Right.
But if you are someone like Ms. Villareal, this doesn't apply to her because she wasn't actually convicted, but if she had been convicted under this and was sitting in a jail cell when she tried to bring this action, theoretically she might have run into a Heck bar, which says, nope, actually you can't bring this 1983 action to get this declaration either. So we've created a universe in which it is next to impossible to clearly establish something as unconstitutional. And also, if it can't be clearly established as unconstitutional, then there's no lawsuit. There's immunity for whoever has done the unconstitutional thing. And
as this case establishes, like the district court in Texas, so like the trial court said the law is unconstitutional. The state or the city didn't appeal it, and so there's no, even within Texas, there's no circuit court holding that this law is unconstitutional. It's still on the books. So now if this case, a very similar case,
holding in this case,
even though that was the holding in this case, that doesn't prohibit another court, maybe even the same court, I mean, that's arguable, but certainly another county from trying to enforce this law that has been held to be unconstitutional has never been successfully enforced.
Yeah.
Which brings us to the opinions that underlie this particular decision. So we have two separate Fifth Circuit opinions, and I don't think we need to go into too much detail about the two Fifth Circuit opinions that underlie this denial of cert. But I do think that it bears mentioning that the first time this comes up to the Fifth Circuit, they go into a lot of detail, both about this qualified immunity issue and about some other kind of side issues that are not real relevant to our conversation today. And then when it's GVR'd, it is sent back talking about one of those kind of side issues. So the second time this comes in front of the Fifth Circuit, those opinions are less relevant to our conversation today. So when we talk about the Fifth Circuit en banc, we're basically talking about that first time that this bubbles to the top. And then it is a very split court in that initial Fifth Circuit opinion. We've got conservative judges, originalist judges on both sides, but we also have, I would say, some pretty heated disagreements between and among the judges about what this rests on.
Yeah, and it flips every time it gets in front of a court on the way up. It flips, right? So the district court says, "Oh, qualified immunity applies." Then the panel says, "No, it doesn't." Then the en banc says, "Yes, it does." Then the Supreme Court sends it back down again
with a vacator, which means they won. She won at the Supreme Court the first time.
Yeah, but on a narrow issue, and so. And so
to be reconsidered.
Yeah, so you can see, like, I mean, and it's deeply divided. We have lots of dissents. So it's not like this is a simple case, but the underlying law that we're talking about is very simple. It's like, are you allowed to, as a reporter, to ask questions? Pretty much.
So let me ask you this, Nathan. We've had a lot of conversations in our office about qualified immunity, and I know where you stand on this. So take this for what it's worth. Will you steel man for us? Give us the best argument that you can in favor of qualified immunity.
Yeah, so I drew the short straw. So
you did. This is me thrusting this upon you, not positions that you actually take.
Shame.
I think the nucleus. I'll say this. I think the nucleus of qualified immunity is that when you have that officers are not constitutional lawyers. And when you have a guy who's 19 years old, just out of high school, has gone through police academy training for a year, and is now going in and he's serving an arrest warrant for someone, that it's not, we're not thinking that person should know all the nuances of the First Amendment. So what they're arrested this person for is basically a reporter asking questions. This is maybe one of the more clear statutes that maybe a new officer would be able to, well, if he really thought about it. But the way that it's framed is not reporters can't ask questions. It's framed that soliciting public information for a benefit. And so even reading the statute, a person might reasonably think, well, maybe this is more like corruption type stuff. Like I'm trying to get secret stuff so I can like make a stock purchase.
There are probably applications of this statute that might not run afoul of the First Amendment, because actually the state court opinion that struck this law down was also on vagueness ground. Like the reason it violated the First Amendment was because it's too vague and it's too overbroad, meaning only some of the applications violate the First Amendment and some others don't.
Yeah, and so should a police officer, and like I'm just going to use like the most sympathetic one who's just brand new and not educated on the Constitution or anything like that, should that person be expected to know all the contours of the First Amendment, like what activity is protected and how it's protected? Or should they just be able to rely on what their supervisors thought about? In this case, there's an arrest warrant. So a judge has looked at the facts of this case and said, we can arrest this person. So the judge has decided, it hasn't been an adjudication that is constitutional, as it was eventually adjudication was that it was unconstitutional, but the judge at least didn't see an immediate red flag that we can't enforce this law because they signed a warrant. And so should that person, that police officer, be held personally liable for relying on a judge, relying on a supervisor? And we'll set aside maybe this person that I'm in this hypothetical wasn't the one who was surrounding the journalist and jeering at her and taking pictures. Maybe all he did was just put the cuffs on her and put her in the back of a car or put her in the jail cell for violating the law. So should that person be held liable under Section 1983? And I would say no, that sovereign or that qualified immunity should not protect that officer. Or it should protect that officer.
Yes.
And to be clear, that is a policy argument that you're making. That's not born out of the text of 1983 in any way.
Yes.
And I say you're making.
I can't believe you would make that argument.
Good Lord, this argument that I just asked you to make. But
yes,
that's the argument
that's
that is here and that people make with a straight face. Conservatives, liberals, a lot of people make this argument. But it is born out of policy. It's what should we expect of officers, not what do we expect of officers under the text. Judge Willett in his dissent answers that exact question in what I think is just beautiful language in his dissent to the first en banc opinion. He says, in the upside-down world of qualified immunity, everyday citizens are demanded to know the law's every jot and tittle, but those charged with enforcing the law are only expected to know the clearly established ones. Turns out, ignorance of the law is an excuse for government officials. Such blithe rules for thee, but not for me nonchalance is less qualified immunity than unqualified impunity. So basically, we all know this, right? The ignorance of the law is no excuse. This is how we practice law. It would be impossible to enforce law if we didn't have that presumption. But at the same time, in the upside-down world of qualified immunity, we impute ignorance on our officers instead of imputing knowledge on our officers.
And it's even worse too, considering that it's the officers who actually have the oath. I mean, we'd hope that we all have an allegiance to the Constitution, but they have sworn a specific oath to the Constitution in their own individual capacities, regardless of what everyone else around them is doing. And so the actual text of 1983 just sort of emphasizes that.
Yeah,
and
if you're going to swear to uphold the Constitution, we should expect that you have a pretty solid grasp on
ignorance.
what the Constitution actually says. Yeah.
I'll offer this one more, maybe not my last one, but one more support for sovereign immunity is that the concept of immunity does go back into the common law, so that we can look back at England, for example, and that public officials and the king, the sovereign, were immune in certain situations. But so like the king was sovereign wherever he said, I'm not, except where I allow a lawsuit against me.
You can't sue me without my consent.
Right. But even public officials in ministerial roles were sometimes held to be immune under the common law in England. And so some of that is perhaps in the background here. And that's the court wasn't grasping at nothing. They were just maybe grasping at very little.
And look, I mean, there have been some, originalist thinkers. I think Scott Keller wrote a law review article about that there are certain common law immunities that you could perhaps read in to 1983. I think the problem with that, from a textualist perspective, is that when you look at the text of 1983, Congress knew how to create immunities because it created one for judges. Mm-hmm. It didn't create immunities in 1983 for anyone else. And that language was absolute. And there was a reason for that. Because if there's no one who has a skin in the game who's just saying, look, I'm just following orders. If everyone's I'm just following orders and there's no liability for anyone, not only do you have plaintiffs whose rights have been violated and they have no redress if there's not anyone they can sue, but also the officers are just going to continue to violate the Constitution if there's no skin in the game. And that's why they created that, Congress made that policy judgment in 1871 when they passed the Klan Act. And maybe you can disagree with that policy judgment, but the text doesn't let you do it, would be my critique there.
They specifically targeted the tip of the spear of enforcement officer.
Yeah. And I think that you do run into a problem where the officer says, well, my boss told me to do it. A judge told me to do it. Someone who's immune told me to do it because you have sovereign immunity and the judge-based immunity in 1983. And so you can't go after the officer if there's qualified immunity, you can't go after the officer. And then because of sovereign immunity, you can't go after the police department. And so then there's literally no way to get compensation under the act, which is specifically to get victims of civil rights abuses compensation. So that is a problem.
To be clear here, Nathan, you have taken off your pro-qualified immunity hat.
Sort of.
Am I understanding
because what I'd like to see is if they're going to, that they can't, there's like a meme where there's a bunch of people in Spider-Man costumes pointing at each other. And I would like to see a judge just say, we can't have this situation happen. Somebody's got to have their mask off.
The buck has to stop somewhere.
Yeah. Somebody's got to have their mask off and be liable to suit. We just got to figure out who that is.
And it's important to point out that there's been a lot of studies on this. Ordinarily, officers are indemnified by their department. So when you're suing an officer for violating, the civil rights of someone, ordinarily they're going to be indemnified by the police, by the department, or by the city in some way. So it's not really coming out of their bank account. But I think that, to your point, as long as there's someone there, I mean, ideally, if it were an ordinance or a statute, you would just sue the state or the city directly. But you can't do that because another made-up doctrine called sovereign immunity.
I think it's important, too, to go back to that language of the statute itself of 1983 that says it's any person who's acting under color of statute, right? It's not just somebody who's out willy-nilly violating people's rights, they're acting under color of a statute, which means that the expectation is that the state has already done something unconstitutional. And that's kind of where Sotomayor's Sotomayor's dissent to the denial of cert picks up, is talking about this perverse incentive structure that's created when we say the state has created this statute, and so if you have probable cause to believe that this violation has occurred, now you have qualified immunity from suit. You've created an incentive structure where the state has an incentive to not appeal all of these things and defend the constitutionality of its own statutes, and then to continue prosecuting at the district court level all of these injuries.
And it's important to point out this isn't a situation where, some police officer is making a split-second decision, right, like while someone's shooting at them or they're in a high-speed chase, and therefore we're going to say that's reasonable under the Fourth Amendment. Here you're talking about a concerted effort by multiple government officials to swear out a warrant, to enforce that warrant, to hold that person in a jail cell, to mock them while they're there. Like, this is an extended tree of decisions by a number of people.
And allegedly with legal advice from the Webb County District Attorney.
Right, with an a statute that has been on the books for a long time. So this is not a split-second decision where you're saying, oh, I'm second-guessing the reasonableness of someone whose life was being threatened. This is, can you hold people liable for violating people's constitutional rights? Or do they just get full-blown immunity because they can point to some statute that was on the books already?
Well, let me jump on the chink of the armor that you just revealed. What about when there is a split-second decision? The officer has literally seconds to decide between preserving his own life and violating someone's constitutional rights. How is the officer supposed to act in that situation?
So in most cases, so I can tell you how it plays out today where qualified immunity applies, and where it would play out in the absence of qualified immunity, or how it played out in the absence of qualified immunity for the first 75 years after the 1983 was ratified. Yet we still managed to have police departments during that time. So the way that it would apply under qualified immunity is you would first have to say, is this something that there's a case directly on point for? So there's great examples where, someone sees a dog when they're serving a warrant, they get scared, they shoot at the dog, they end up shooting someone's kid, they get qualified immunity because there's not a case directly on point that says you can't shoot at dogs without looking to see if there's a kid behind the cage, right? Like, these are like real world kind of examples of where this happens. That would be qualified immunity. That would mean you don't go to trial, there's no discovery, no one determines whether or not your choice was reasonable or not. It's just that there's not a case directly on point, so the case is dismissed. In the absence of qualified immunity, when you're talking about a seizure like that, so for example, usually when you arrest someone or you seize them, those sort of split-second decisions you're talking about, without qualified immunity, the Fourth Amendment has a reasonableness test.
I'm going to take you on a timeout because there's a little jump that I think you just made.
Yeah.
Why do we jump from a First Amendment violation to a Fourth Amendment violation? Why does the Fourth Amendment violation matter?
Because typically the way that you would sue for an unlawful arrest or excessive force, which is what he's talking about, these sort of split-second decisions where their life's in danger, so they shoot someone. Usually those are adjudicated under the Fourth Amendment, right? You're claiming it was an unreasonable search or an unreasonable seizure whenever they are unreasonable use of force under the Fourth Amendment.
Or an illegal arrest, something, especially in this context where what she's suing under is the First Amendment in the sense that she's saying, you violated my First Amendment rights by arresting me under the Fourth Amendment for what was an unconstitutional statute.
Right.
So it's a First Amendment challenge, but under 1983, we end up couching it and framing it as a Fourth Amendment challenge most of the time.
Yeah, that's fair.
So how does that make a difference here in the context of reasonableness and how this plays out?
Well, before I get there, let me just finish unpacking the way that it would work in the absence of qualified immunity. In the absence of qualified immunity, if there was a split-second decision, something like that, it would be the question of whether that split-second decision was reasonable given the circumstances. And the only difference would be is that there would actually be evidence produced. There would actually be, a jury or a fact finder that has an opportunity to look at that and decide whether or not it was reasonable. So, it doesn't mean that the officer loses and the officer has to pay. It means that someone gets to actually decide whether or not it was reasonable in those circumstances, in those split-second circumstances.
But this is why I bring up the Fourth Amendment, First Amendment distinction, because the Fourth Amendment only makes unconstitutional, unreasonable searches and seizures.
Yes.
So if you show that this was a reasonable search or seizure of a person, then you are now in a place where it's just simply not unconstitutional. That verdict is no liability because 1983 does not apply to constitutional acts.
Right.
So if it is reasonable under the Fourth Amendment, it is constitutional. And because it is constitutional, now it's no longer a violation of 1983.
Right. That's something to remember. Qualified immunity really only
makes sense in the Fourth Amendment.
Well, it really only makes sense when a constitutional violation has happened.
Right.
That's where it's doing its work, is where someone's rights have arguably been violated. Because if their rights clearly haven't been violated, if the action was objectively reasonable, you could dismiss the case under what we call a 12b-6, which is a motion to dismiss.
And that happens all the time. Qualified immunity kicks in only in the cases where someone might actually believe there was a constitutional violation, which makes it a particularly kind of interesting read into a statute that's designed to protect constitutional liberties.
And in a lot of ways, we end up in exactly the place where we are now, where it's blazingly, obviously unconstitutional statute, but there's nothing that anybody can do. We can't even get discovery. We don't even get to that place.
Well, they don't know whether or not she was, part of the argument I believe is that she makes is that she was retaliated against, right? Mm-hmm. And retaliation claims, having litigated them before, those require a ton of discovery. Right? It's really hard to prove that someone was retaliating against you when they enforced a law.
And retaliation meaning that she's doing reporting that they don't like, and so they're just like, let's get her.
Right.
And so it's almost like you almost have to have like sort of a conspiracy sort of thing going on behind the scenes where they're like, we got to find some law she broke. And so the reason you need a discovery is to get all those conversations and all that kind of stuff. And so it's a very long, detailed case.
But if qualified immunity applies, you don't get any of that discovery. You don't get to prove your case. You don't get to show that this wasn't, them objectively enforcing the law. This was them trying to, for example, just, find a way to go after someone that they didn't like for what they said. And when it comes to, retaliating for First Amendment protected speech, that's unconstitutional as well.
So there's an issue here that's raised and discussed a little bit in Justice Sotomayor's opinion. Well, first of all, let's start here. This is Justice Sotomayor's opinion. Why do we only have one judge on this? Do we know?
We don't know. Sometimes people decide to join dissentals, sometimes they don't, and the reasons why they don't are completely private. It's something that's private to the court.
And this is not like Justice Gorsuch's dissental that we talked about a few weeks ago, where you could look back on the preceding opinions and kind of cobble together a theory about what we really, truly do not know why this was denied. We truly do not know why. There's no further conversation about it. It's just... And
it's particularly strange because a lot of the other justices have written about this issue before.
And she quotes them. She quotes Justice Gorsuch. I think she quotes Justice Thomas. She points back to things that they have said. Let's see if I can find her quote from Justice Gorsuch when he was on the 10th.
I mean, that's an important thing to point out. I mean, Justice Thomas is no, wilting flower. He's no progressive. He is one of the most dyed-in-the-wool originalists, and he has long questioned qualified immunity for the reasons we're talking about, like the basis of the text in 1983. And that's one of the things that she was pointing to is like, why aren't you joining?
Yeah.
If not now, then when? Because this is pretty clear. I mean, this is the First Amendment, that's just the context is right for it.
And this is the quote that she pulls from Justice Gorsuch from his time on the 10th Circuit. It would be remarkable if the most obviously unconstitutional conduct should be immune from liability only because it is so flagrantly unlawful that few dare its attempt. And I think that is really very much the crux of this. And I don't know if the justices didn't agree that this was flagrantly unconstitutional, I mean, we can't know. We can't know what the answer is there. Setting all of that aside, so Justice Sotomayor writes this dissental, and one of the arguments that she raises or addresses that had been raised in the Fifth Circuit was this impartial intermediary rule, which basically says that your qualified immunity kicks in because a third party, an impartial intermediary, has passed over your case and made a decision that this is that there is probable cause.
So, like in this case, it would be like a judge issuing a warrant.
Right. It was the magistrate that issued the warrant in this case. And Villareal argues that the magistrate didn't have all the information in front of him because there was fraudulently concealed information and that maybe there are some misrepresentations in the warrant application. And so, therefore, that independent intermediary rule shouldn't be applied. But the independent intermediary rule holds, and this is a direct quote from the Fifth Circuit, the magistrate's mistake in issuing the arrest warrant must not be just a reasonable mistake, but an unacceptable error indicating gross incompetence or neglect of duty to get us around that qualified immunity bar. Mm-hmm. Is that, it sounds ridiculous to say, is that in the text of 1983?
None of this is in the text of 1983.
Oh, you're still thinking about the text?
Oh, yeah.
That's cute.
That was so 20 years ago, 30, 40 years ago. How long has this been a problem now?
But at this stage of the proceeding, where this proceeding was, we should be taking all of her allegations as true. So it's like, she said this, but the court has to consider that to be true for the purposes of the pleadings and whether or not she gets to proceed with her action. So assuming that that she's right about what she's saying, that the judge was maybe not doing his job or her job, or and that the officer, like everything that we're saying, the officers really did surround her and take cell phone photos. Mm-hmm. We don't have evidence of that. We don't know for sure. But they have to consider that to be true. And so in that posture, I think that's like one of the best postures for the Supreme Court to make a rule of law where you have all the plaintiff's allegations as true. So I would have liked to see at least more justices on this dissent.
Where there's less of a fact fight.
Right. There is no fact fight at the motion to dismiss stage. We're just assuming that you're correct. If there's a fact fight, we send it back.
Is
for
there
fact.
though?
Do y'all think that maybe part of the reason that no one joins is it is sort of a weird vehicle in the sense that it's dealing with, you have the intermediary doctrine. It's not just a straight up qualified immunity case. You have all of these other intertwined doctrines that you have to sift through. So maybe it's not the cleanest vehicle if you wanted to reconsider.
But they wouldn't be reconsidering it. They could just point out that they should reconsider it. They could still say something.
It also, to me, is like we've been gardening recently. We've been ripping up my backyard, and we've got one particular bush that just sent out tendrils everywhere. And the easiest thing has been to just cut off that bush at the root and then find these tendrils and yank them out of the ground. If we had just cut it off at the root instead of going through and trying to find all the tendrils beforehand, it would be a lot easier to remove everything.
Yeah,
you're going to make a bigger mess if you write opinions in a vehicle that isn't correct.
If we just did a watershed, turn this over, no more qualified immunity. Sorry, guys, you can fight this out in court on the reasonableness standard. And then all of these other doctrines have just gone away.
I don't think we have the votes for that, right? Like maybe a limiting.
Well, and those doctrines might be present in other places in the law where they don't want to take them away, potentially.
Yeah, I mean, it's a lot of the folks on the court, we don't know where they shake out on these issues. And of course, the law enforcement thing complicates things. Mm-hmm. There's that complicating factor.
There's the bad man stays in jail problem.
There's a bad man stay in jail kind of problem, even though in this case you're talking about damages. You're not talking about staying in jail.
And she's not a bad man.
She's good.
Yeah.
She's a Gordiloka.
The Fifth Circuit, the justices on the Fifth sort of seem to think she's a bad actor. Like in their majority opinion, they impute some malice to her that we don't see in Sotomayor's opinion. But I kind of wonder if she said some things that would even make us at this table cringe. But again, First Amendment doesn't care if you are indecorous.
Right, and they were sort of concerned about like the subject matter of this particular case. It was the names of victims, and maybe they wanted to protect the victims.
Yeah, that was something that was pointed out very early on in the Fifth Circuit opinion. Is this was very specifically names of victims that broke in the news before officers had the chance to talk to families. Like,
right.
It is indecorous.
Because it's important. It's important to remember that the Supreme Court, unlike the appellate court, doesn't have to take cases.
Right.
You know, it gets to choose the vehicles that it wants. And And so maybe they looked at that and they're like, that's complicated. We don't like the facts. We only take, at that point, they're only taking 65 cases a year at this point.
Yeah.
And so they'll just wait. The court can wait till they get a case that they want to take to address maybe the issues that Sotomayor raised. Or
when we say vehicle, we're talking about the case and the facts that go with it. Is this a good way to get a rule of law?
Yeah.
So
if it's not worth taking the case, maybe it's not worth writing a big dissental opinion about it either.
Yeah.
It's also an interesting issue in that we don't really have settled law except for a couple of Eighth Amendment cases like we talked about before dealing with obvious unconstitutionality. There's not really a circuit split on this obvious unconstitutionality issue. There's not really anything binding in the Fifth Circuit on. So it might also be that they're waiting for that to reach a pinnacle of some kind, whether obvious unconstitutionality meets that clearly established standard. I think the assumption, at least according to Sotomayor, the assumption is it always has. But the other justices didn't necessarily agree with her and sign on to this. So
maybe a law that has never been prosecuted before is not the best vehicle.
Yeah.
Right.
But Sotomayor would disagree with that. So in her dissent, she sent a dissent from denial. She's saying, even though this specific fact situation hasn't been, that she says when a general constitutional rule already identified in the decisional law applies with obvious clarity to the specific conduct in question. So that's it's kind of a long way of saying that. But she's saying there could be, even if it's never been adjudicated, there could be a defeat of qualified immunity. And that would be a breath of fresh air. Even if we're going to retain the doctrine, we have to be able to look at the law and be like, okay, obviously in this case, qualified immunity doesn't apply. And I think if I'm defending qualified immunity, that's what I want. That's what I would want, is to at least limit the doctrine to like more of the places where it's more common sense applies, and where you can't just constantly jettison these cases.
Well, you've come a long way since your previous
persuaded.
In the last 32 minutes.
I think a hypothetical really proves the point. Imagine that there was like some crazy city that decided that it wanted to ban Christians from going to church on Sunday. And it passes an ordinance that says no church on Sunday. And so then it tells its police officers to go arrest everyone in Austin First Baptist Church this Sunday afternoon. And it issues a warrant. I mean, wouldn't you think that those people who are arrested and thrown in jail should be able to go to court and challenge that and maybe get damages for the 2 or 3 days they spend in jail? Their kids, were scared to death by the police officers.
You might lose your job if you're sitting in jail for 2 or 3 days.
Right, and you would think that those people would have some sort of recourse under 1983, despite the fact that, of course, no city has ever passed a law before that says you can't go to church on Sunday.
Well, I mean, we do have COVID, but...
those are the closest they get, yes.
Setting that aside, I think they do have remedies, so they can get the law enjoined. They can get an injunction saying the law is unconstitutional and can't be enforced.
Again, assuming they're not running into a heck bar, which is its own problem.
Well, let's say someone could like sue about the law in advance,
but they get no relief at the end, and there's no damages that are paid out to make them whole again. So someone always has to eat the loss. It's either going to be the city who passed the crazy ordinance, it's going to be the person who had their rights violated, or it's going to be the person who was the tip of the spear in violating their rights. But someone is ultimately going to have to eat that cost, and the question is should it just, under qualified immunity, it's ordinarily just the person whose rights were violated, which is a weird thing given the text of 1983.
Well, and also just given American jurisprudence in general, right? We come from a history of no right without a remedy. We come from a history of saying if your rights are violated, you should be able to receive some sort of compensation for that.
Yeah.
And qualified immunity turns it on its head and says, no, you have to bear the cost of our mistake.
Yeah.
You have to bear the cost of the government's mistake, which is just, frankly, un-American.
Yeah.
The government or the officer's mistake. And I think one of the most heroic, I think most people would agree, one of the most heroic things that a police officer could do is to say, I will not enforce this law because it's violating someone's constitutional rights. And a very broad interpretation.
And I do want to give a shout out to that. So I have known so many cops, and I have fielded those phone calls from cops saying, hey, there's this thing that I am considering doing. Is it constitutional or not? Because they're conscientious of this.
Yeah.
Because they actually do care.
Yeah.
And I have known cops that have told their superiors, no, I'm not going to do that thing. Like, they do. There are cops that behave this way. And making that the expectation and the understanding that that's the way that it should be, I think is not asking too much for most law enforcement.
And so we want the incentive structures to align with that principle, that they should be encouraged to, if they think a law is unconstitutional, say, I'm not going to enforce it. And what qualified immunity does is it removes one of those incentives, saying, if I do enforce this law that I believe is unconstitutional, there's no damage that's going to come to me from that. And I think that's one of the flaws with qualified immunity right now, for sure.
Mm-hmm. Yeah, it's just, it all comes down to the perverse incentive structure that's created.
Yeah, and that principle also is not just it's not like it was just invented in Section 1983 after the Civil War. It's like a bedrock American principle. St. George Tucker's commentaries on American law is to be distinct from British law. This principle that you're not just, that there's an immune sovereign that like covers over the land is like from OG day one.
Yeah. Well, I think that brings us to the end of today's docket. If you've enjoyed our conversation or you have thoughts and want to weigh in on this qualified immunity issue, leave us a review. Let us know what you think. We'd love to hear your comments. And join us next time for more Rightly Decided.